This is Barry Zalma speaking for Zalma on Insurance on YouTube. I am an attorney who has retired from the practice of law and now spend my time acting as an insurance claims consultant, an insurance claims expert witness, and as an author and creator of these YouTube videos. Today we will continue with the claims commandments, 15 of which have been created and will be on this channel as I record them. I am not Moses. I haven't a direct communication with the Almighty, but I do have 52 years of claims handling experience and hope you will find these commandments useful in your practice. Claims Commandment 3, Thou shalt communicate often. Insurance claims is a service business. The claims person provides a service to the insured and the insurer. Communication is essential to providing the service promised by the insurance policy. In some states, in fact, like California, communication is required by regulation. The California regulation provides, quote, every insurer shall disclose to a first-party claimant or beneficiary all benefits, coverage, time limits, or other provisions of any insurance policy issued by that insurer that may apply to the claim presented by the claimant. When additional benefits might reasonably be payable under an insured's policy, upon receipt of additional proofs of claim, the insurer shall immediately communicate this fact to the insured and cooperate with and assist the insured in determining the extent of the insurer's additional liability. Close quote. That's 10 CCR 2695.4 paren A close paren. This means, simply, the initial written contact with an insured in a first-party property claim should advise the insured of all benefits, coverage, time limits, or other provisions of any insurance policy issued by the insurer that may apply to the claim presented by a first-party insured. When a claims person receives any communication from an insured, third-party claimant, or a representative of the insured or claimant regarding a claim that reasonably suggests that a response is expected, the claims person must immediately, after receipt of that communication, furnish the claimant or insured with a complete response based on the facts as then known by the claims person. Some regulations allow the claims person up to 20 days to respond. Good claims handling practices require an immediate response. If the response is oral rather than written, the response should be noted in the claims person's file or computer-based log. Upon receiving notice of claim, every insurance claims person should immediately do the following. 1. Acknowledge receipt of such notice to the claimant or insured. 2. If the acknowledgement is not in writing, a notation of acknowledgement must be made in the insurer's claim file and dated. 3. Provide the claimant or insured all necessary forms, instructions, and reasonable assistance, including but not limited to specifying the information the claimant must provide for proof of the claimant's claim. And 4, begin any necessary investigation of the claim. The investigation must be real, meaning the claims person or investigator must actually contact the claimant, the witnesses, and start collecting the documents needed to complete the claims investigation. Investigation must be started immediately after receiving notice of claim. Merely reading a policy wording and notice of claim is not the beginning of an investigation, nor is it any investigation at all. Upon receiving proof of claim, every insurance claims person should immediately accept or deny the claim in whole or in part. The amounts accepted or denied shall be clearly documented in the claim file unless the claim has been denied in its entirety, and the insured or claimant must be advised in detail that the claim was denied in part or in whole and the reasons for it. Some states allow up to 40 calendar days to respond to a proof of claim. Some policies indicate a 30-day period, but the 30-day period is really not a condition. It is a time when the insurer has the right to acknowledge the claim. If more time is required by the adjuster to determine whether a claim should be accepted and or denied in whole or in part, the claims person should provide the claimant or insured written notice of the need for additional time and an explanation why the additional time is necessary and what the insurer's representative intends to do during that time, and what additional information the representative needs from the insured to complete the investigation. The written notice should specify any additional information the insurance claims person requires in order to make a determination. The written notice should state any continuing reasons for the insurer's inability to make a determination, and thereafter the written notice should be provided at least every 30 calendar days until a determination is made. If the determination cannot be made until some future event occurs, then the claims person should comply with the continuing notice requirement by advising the claimant and or the insured of the situation and providing an estimate as to when the determination can be made. Effective diary systems are also essential to professional claims handling, or the regulations requiring prompt response will be violated with regularity. Every claims person must conduct and diligently pursue a thorough, fair, and objective investigation, and should not persist in seeking information not reasonably required for or material to the resolution of a claims dispute. The claims person's obligation is not limited to communication with the insured or the claimant. The claims person and the insurer also have an obligation to communicate with the state, with police agencies or prosecutors when fraud is suspected. For example, in California and most states, such a communication is absolutely immune from suit. Pursuant to section of the California Civil Code, section 47B, a privilege is stated that bars a civil action for damages for communications made, quote, in any legislative proceeding, judicial proceeding, or in any other official proceeding authorized by law, or in the initiation or course of any other proceeding authorized by law and reviewable pursuant to statutes governing writs of mandate with certain statutory exceptions. The privilege established by the subdivision often is referred to as an absolute privilege, and it bars all tort causes of action except a claim for malicious prosecution. Quote, the absolute privilege in Section 47 represents a value judgment that facilitating the utmost freedom of communication between citizens and public authorities, whose responsibility is to investigate and remedy wrongdoing, is more important than the occasional harm that might befall a defamed individual. For example, see a case called Imig versus Farrar, a 1977 Court of Appeal case. To fulfill Commandment III, the claims person must communicate promptly and often with the insured, the claimant, and the insured in a third-party claim and counsel for each. In doing so, the claims person establishes a rapport with the insured and or the claimant and will make resolution of the claim easier. No claims person should ever misrepresent or conceal benefits, coverages, time limits, or other provisions of the policy from the insured. And finally, no communication between a claims person and an insured or claimant should be conducted by use of a form letter. Form letters are common but not specific to a particular claim or claimant. If a form letter is used, it must be adapted to comply with the requirements of a real communication between the insurer and the insured. Claims Commandment IV. Thou shalt understand the policy. Insurance policies are contracts. To understand insurance claims, the adjuster must understand how all contracts, and specifically insurance contracts, are interpreted. Rules of contract interpretation have developed over the last 300 years and are applied by courts with the intent to fulfill the desires of all parties to the contract. Lay people and judges who are not conversant in insurance and the interpretation of insurance contracts believe the insurance policy is difficult to read and understand. As one court said in a case called Delancey versus Rockingham Farmers Mutual, a New Hampshire case, quote, this policy, if read by an ordinary man, would be an inexplicable riddle, a mere flood of darkness and confusion, should some extremely eccentric person attempt to examine the involved and intricate net in which he was to be entangled. He would find that it is printed in such small type and in lines so long and crowded as to make the perusal of the document physically difficult, painful, and possibly injurious. This may have been the case when the Delancey case was decided in 1873. Modern insurance policies bear no resemblance to what the Delancey court reported. The adjuster, the claims person, the claims executive must understand the following rules govern the construction of contracts of insurance. 1. If the terms of a promise are in any respect ambiguous or uncertain, it must be interpreted in the sense in which the promisor believed at the time of making it that the promisee understood it. 2. If a written contract is so worded that it can be given a definite or certain legal meaning, then it is not ambiguous. However, if the language of a policy or contract is subject to two or more reasonable interpretations, it is ambiguous. 3. When a policy is interpreted, the provisions of an endorsement control the interpretation over the body or declarations of a policy when the two are in conflict. For example, if the language written to limit an insurer's liability to the appraised value appears on the declarations page, while the valuation condition that provides for an actual cash value adjustment appears on a form endorsed to the contract, the endorsement's language would control the interpretation of the contradictory language of the standard form policy. However, the fact that the two sentences could have been written more clearly did not mean they were ambiguous. Consider the reasonable expectations of the insured, but when doing so, include the understanding that every insurer is presumed to be acquainted with the practice of the trade he or she or it insures. More than 150 years ago, in 1834, the United States Supreme Court, in a case called Hazards Administrator versus New England Marine Insurance Company, found, quote, "No injustice is done if insurers are presumed to know their insured's industry because it is part of their ordinary business." In McKinnon versus Truck Insurance Exchange, the California Supreme Court first stated the primacy of the reasonable expectations test when interpreting insurance policies. It decided that the reasonable expectations of the insured required coverage to exist for an ordinary act of negligence, even if it involved pollutants that were excluded. Where the language of the policy is clear, the language must be read accordingly, and where it is not, it must be read in the sense that satisfies the hypothetical insured's objectively reasonable expectations. If, while reviewing a policy, you find a term is clear and unambiguous, there will be no need to apply the reasonable expectations test. If, on the other hand, you find any ambiguity or determine the insured should be paid, the application of the reasonable expectations test will give a court the ability to construe the policy against the insurer and in favor of payment of the insured's claim. Most states apply the plain meaning test. Long-established insurance law supports the conclusion that insurers are presumed to know and be bound by the meaning of the terms used and customs adopted in their insured's industries. Insurers and insurance claims professionals, faced with a need to understand and apply the wording of a policy of insurance, must now conduct their investigation to include a detailed investigation of the facts of the loss and policy acquisition, a determination of the expectations of the insured and the insurer at the time the policy was acquired, a determination of the purposes for which the policy was acquired, and an examination of all communications between the insurer and the insured or their representatives. To do so, the insurer must at least conduct a detailed interview of the insured, the claimants, the brokers, the agents, and the underwriters. When there is a dispute over the meaning of common terms, the claims person must understand a court will often find it necessary to inform itself upon the understanding of persons in the particular business insured, so that the judge can consult the opinions of experts. The expert testimony obtained by a court can be helpful in establishing the insured's or insurer's interpretation of the term at issue, and that it is different from that advanced by the other. Prudent claims people will consult with such experts before a claims decision is made and before a lawsuit is filed, to avoid the need for a court to interfere with the claims decision. In California, for example, it may be sufficient for a party to prevail because although insureds are treated differently so that even if the insurer's interpretation is considered reasonable, it would still not prevail, for in order to do so it would have to establish that its interpretation is the only reasonable one. An insurance claims professional can never make or recommend a decision with regard to an insurance claim until he or she has read the entire policy as it relates to a loss as determined by the adjuster's investigation, interpret the policy wording in accordance with the rules of interpretation that we have already discussed, conduct a complete and thorough investigation to determine the reasonable expectations of the insured, and if unable to make a decision, seek the advice of competent coverage counsel and/or competent insurance claims handling experts. The information provided is adapted from some of the parts of my book, Zalma on Insurance Claims, 10 volumes on everything needed to know about first or third party insurance claims for the adjuster or the insurance claims counsel. They are available at Amazon.com as both a Kindle book or as a paperback, and can be accessed through my website, www.zalma.com, by clicking on the Insurance Claims Library link. Thank you for your attention.